Hey, all you cool cats and kittens. My name is Alexis Clay. I'm a staff attorney at the Pro Bono Project. My main practice area is succession, so I'm going to briefly talk to you about those today. Now, succession is basically the settling of a deceased person's estate. In other states, you might hear it being referred to as probate, but Louisiana has to put a little Tony Chachere's on everything for a little razzle dazzle. So we're a little different. So, types of successions are intestate or testate. A testate succession means that a person left a will designating who they want the property to go to. An intestate succession means that the person died without a will. And these can be small or large. A small succession means that the estate is worth less than $125,000, and a large succession means the estate is worth more than $125,000. Now, the main question with successions is who the property goes to. Now, for a will, that answer is very easy. The will designate who the property goes to. But the will has to be valid under Louisiana law. I won't tell you the requirements right now, but there are certain requirements that a will must meet. If they don't meet these requirements, it will be considered invalid, and the succession will have to be intestate. Now, for intestate successions, who the property goes to depends on whether the property involved is separate or community. Now, in a gist, separate property is property that's acquired before marriage or property that's inherited, something like that. Community property is essentially property acquired while someone was married. For separate property, the law favors descendants first. That means your children, or if your children are deceased, their children, so your grandchildren. If you don't have any descendants, then the law now looks to your parents or your siblings to see who the property goes to. And if you don't have any parents or siblings, then it will go to your spouse. Now, if you don't have a spouse, then it will go to your grandparents or other ascendants. That means relatives that are above you on the family tree. And if you don't have any grandparents or ascendants, it will go to your nearest relative. If there is no nearest relative, it will go back to the state, and we don't want it to go back to the state because they have enough things. Community property, it will first go to your children or your children's children, just like separate property. But if you have a surviving spouse, they will get what's called a usufruct. It's a very weird word. You might have seen it somewhere or heard it somewhere before. But a usufruct just means that that person has the right to use the property. And a surviving spouse will be able to use the property until death or remarriage. If you don't have any children, then it goes to the surviving spouse outright. And if there's no spouse, then it's treated as separate property and it'll devolve by those standards. So I want to circle back to small versus large successions so we could talk about what types of filings they are. Thankfully, in recent years, laws have been passed to allow for a small succession affidavit to be executed so that people won't have to go through court. So it'll save time and it'll save money. Now, if the estate is worth less than $125,000, then you can file what's called a small succession affidavit. This can be drafted up and signed by two heirs of the succession in front of a notary. Note that if there's a surviving spouse, they must be one of the signers. So once this document is notarized, it can be filed in land records if there's a house or land involved. If there's not, if there's just what's called movable property, like a bank account or a car or something of that nature, then it doesn't need to be filed. You can just send it with your client on their merry way and they can give it to the proper parties. Now, large successions and testate successions, you will need to go through the court and file what's called a petition for possession. This will include what's called an affidavit of death, jurisdiction, and heirship that just tells the court this is the person that died. They died on this date, they lived in this place, and they had these children or grandchildren. You also need to file what's called a sworn detailed descriptive list, which lists the decedent's property and the value of the property, but it will also list the debts if they're known. The debts are also included in the succession. And when you do a succession, the heirs or legatees accept those debts. So if there's a will, you will also need to include a petition for probate of the testament so it can be recognized. And then lastly, a judgment of possession will need to be included. And this is the part that the judge signs off on, putting the heir or legatee in possession of the immovable property. Now, this judgment, after it's signed, must be filed in land records if it involves a house or land or any immovable property. So I hope this was helpful. If you know someone that needs a succession or if you need a succession, feel free to call the Pro Bono Project at 504-581-4043 so we can see if you qualify for our services. If you're an attorney out there and you wish to volunteer and take on a succession case, feel free to reach out to us. Even if you're new to it, I'll be here to help along the way if you need any assistance, so you won't be left out there alone. If you have any questions about this video or about successions in general, my email address is aclay, A-C-L-A-Y, at probono, P-R-O-B-O-N-O, dash N-O.org. That's aclay at probono-no.org. Feel free to reach out to me. I'm available anytime to answer questions. Thank you.